Time again for Behind the Law with Dennis Vetrano. Welcome back, Dennis.
Good to see you, Joe.
This is my show today. I've got to ask you a question. We've been doing this for how many years now?
Yeah, well, a while. How many shows?
Hundreds and hundreds.
Right.
Now, you know I'm a big Perry Mason fan.
Yes.
And so often when you're watching Perry Mason, they say, I'm going to have to treat this person as a hostile witness.
Yes.
What is a hostile witness?
Oh, my God. Listen, and I want the listeners to know, we have so much fun off the air here before we do this show. We were laughing out loud about this. So I was like, we have to put it on so people can hear it. Because I love evidence. I've been fascinated with it my entire life. I took a lot of it in law school, and I've tried a lot of cases, so I find it fascinating. So a hostile witness is when you call a witness and you expect them to testify to one thing, and it turns out they testify to something different. So there's let's say, legal term of art, there's a foundation, which means a line of questioning you need to get into to be able to treat someone as a hostile witness. You know, so let's say it's a protocol for lawyers. So you asked your question, you say, you know, when you call a witness, you're only allowed to ask open-ended questions, which means who, what, when, how, those sorts of things. Closed-ended questions are questions that you can only answer in a yes or no. So you would ask, I would say, Joe, you have a brown sport coat on today. True?
That is correct.
So you could say yes or no, but you really couldn't answer in any other way. Whereas if I was asking you a question on direct and I initially called you, I'd say, Joe, what color sport coat do you have on today?
And I would say brown if I was telling you the truth.
You could say brown, you could say purple, you could say whatever you wanted. So it would allow you to elaborate and explain. Now, if I say, Joe, what color sport coat do you have on, today?
Blue.
So if you said blue, now I could go into a line of questioning, which were closed-ended questions, because now you've testified to something that I didn't expect you to testify to. Now, judges vary. Some judges require you to go through the foundation and ask for permission to treat them as a hostile witness. Most of my experience was before a judge who was really enamored with the art of the practice of law, and he wanted you to almost creatively, artistically flow through it naturally. And that's my base and experience, and that's the way I do it. I don't ask for permission. If you testify to something and it's apparent that it's not what I expected you to testify to, then I'm going to naturally, when I've laid the appropriate foundation, flow into hostile witness level questions, which are closed-ended questions, which you can only answer in a yes or no.
Next time I watch Perry Mason, I will think of you, Dennis.
Yes. Yeah. Oh, I love the rules of evidence. It's so fun. Evidence is awesome.
To find out more about Dennis and his firm, visit that website.
drvetranolaw.com.
Dennis, thanks a lot.
Good to see you, Joe.